What's up, everybody? It's the Digital World Podcast, and I want to talk about this case and what it means. I want to kind of go into a deeper dive, and I'll be using our top two XRP community lawyers that are helping this community out a lot. Without them, we'd be a little bit lost. So they've definitely been doing a great job of guiding us and giving us direction and clarification on this space. And to them, I am thankful on behalf of the community, which I'm sure are very thankful for their efforts. I want to start with this. Johnny Deaton said this on Twitter. He said, every digital asset project likely starts off as a security. Even Bitcoin could be argued as an investment contract during the early days. In fact, former SEC News chief Joseph Grunfeld opined at one point that he thought Bitcoin was being used as a security. Okay? Now, that's interesting because there are some reasons to believe that, yeah, a lot of the assets, especially the top ones, like he just said, Bitcoin initially, and we've obviously seen Ethereum with Vitalik Buterin doing basically an ICO blatantly. And however, we have heard the SEC says you can start as a security and then become a non-security. So we do know that. And here's a thread that Johnny Deaton referred to that he posted on the 31st of January. He said, and I'm going to read it because this is really important. And stay with me because you're going to want to know what he's saying. So he's saying crypto versus crypto, XRP versus ETH versus Bitcoin. I've been pounding the table for weeks that the crypto community needs to come together and unite against an overreaching government. Instead, the Bitcoin maxis seem as they want the SEC to crush all the fake wannabe S coins. Of course, I always believed that the Bitcoin crowd believed in free market capitalism. I always believed it was the market that decides who wins and who loses, not the SEC or any other government agency. It's Bitcoin that should shut down the competition. Of course, Ethereum maxis feel protected because no one person from the SEC in 2018 said ETH was no longer a security. If you hate XRP because you don't like the fact that Garlinghouse sold some of his that he was paid as part of his executive compensation, but you love ADA or Algo, etc., you should not hope that XRP gets killed off. Make no doubt about it, Ripple is fighting for its very survival, and I completely agree with those statements. We all know Ripple's lawyers have filed Freedom of Information Act requests for all documents, emails, correspondence, and or anything related to SEC, considering that ETH and Bitcoin are not securities. As a trial lawyer, let me explain what this Freedom of Information Act request signals. It means if the SEC is putting XRP on trial, Ripple is putting ETH and Bitcoin on trial. Ripple will clearly argue that if XRP is a security, so is ETH, and maybe in some instances, so is Bitcoin. So this is not about just XRP. And for those people who are invested or are maxis of Bitcoin or ETH, they should be concerned as well because this just doesn't apply to Ripple and its native token because they're asking for Freedom of Information Acts on Ethereum and Bitcoin to see how they got their classification. They want to get documents or anything, any kind of information that will allow transparency from the SEC in regards to how they came to the conclusion that the top two digital assets in cryptocurrency got their classification. So the fact that Ripple got dragged into this lawsuit also is dragging Ethereum and Bitcoin, and so that's why this case is so important and big because it could be um, possibly that it ends up classifying the whole space, and so that will be very interesting to monitor. Now, he says, I'm sure Ripple's lawyers will argue to the jury and judge that clearly none of them are securities, but the SEC can't make a valid securities distinction between them. Ripple's answer repeatedly makes the case that Ripple never held the traditional securities offering. I can guarantee you that Ripple will attempt to draw distinctions between what it did when distributing tokens versus what Vitalik did. The clip below, which he shows, and you can go watch it, are, and it shows how he's blatantly doing an ICO. It's very blatant. He says, I tweeted that Ripple's lawyers are arguing that calling XRP security today violates principles of fair notice and due process of law. Ripple's lawyers will attempt to show the inconsistent treatment between ETH and XRP and that it was reasonable for Ripple to assume XRP would be treated similar to ETH and Bitcoin. And he said in his last tweet, he called, you know, the due process argument brilliant, and he goes on. And then he says, I wouldn't be surprised to hear Ripple's lawyers discuss how Bitcoin mining pools constitute common enterprises promoting Bitcoin the same way Ripple promotes XRP. And see Gary Gensler below. He attaches a clip. You can go watch it. But the point he's trying to make here, which I stated before, is this is an all crypto trial. Okay, this is not just an XRP trial. It's for the whole space. And he says, for those of you that call the Ripple executives greedy dogs or any other greedy animal, what happens when you back that animal into a corner? Even a kind and friendly dog will bite back. Ripple's fighting for its very survival, and it has a team of all-star trial lawyers who will defend Ripple to the end. That means highlighting the other crypto projects to demonstrate the fundamental unfairness and violations of fair notice and due process. It's not throwing the other projects under the bus. It's called good lawyering. Like I've said, all of crypto will be on trial. And he just crushed this out of the ballpark. I mean, I couldn't explain this any better than what he just did. And folks, this is, I'm telling you, this is the trial of the century. This is going to determine what happens to the digital asset space. And be certain that clarification for the whole space will happen. I don't know when, I don't know how exactly it's going to pan out, but it's here and it's coming. And it's just a matter of time, okay? And prepare your bags because this is who knows when it happens, but I do believe there's going to be some rocky times ahead, and so we'll just have to see. We'll just have to see. Now, Jeremy Hogan said this just today. The SEC filed another lawsuit against a cryptocurrency company, LBRY Inc., and the LBC coin. Ripple wasn't the first and won't be the last. The whole industry is at risk. I'm telling you, what I just went over on John Deaton's thread, it applies to the whole space. And Mickey Refresh posted this video that I thought you guys should watch. He says it's always been about SEC bringing Ripple Labs under SEC control and full oversight. SEC was now building a case for 30 months to prove XRP a security now. Claim was focused on one thing, Ripple register with SEC. And he says the CFTC, huge ally of Ripple, that they'd be stuck under SEC forever. Now let's go ahead and watch this video.
That there's been a fair amount of consensus after the 21A report on what the law kind of is now. I'm wondering, so when you're going after issuers and lawyers, what's their response to the enforcement actions and subpoenas? Is it like just kind of put their hands up and say, sorry, you caught us? Or do they have like certain arguments that they make? And I'm wondering what you're hearing back.
I think that's a good question. I don't have a specific answer because one of the reasons I'm pretty comfortable when I say the law is getting a lot clearer is the reaction has been, yeah, okay, you're right. We should register. This is a security. We should register. So.
Yeah. Well, it's part of the mystery. Very simply, is there are three enforcement.
We should register. This is a security. We should register. So.
Yeah. Well, it's part of the
action has been, yeah, okay, you're right. We should register. This is a security. We should register. So.
Yeah. Well, it's part of the mystery. Very simply, is there are three enforcement actions that the agency has brought. One of the three settled immediately. It's the Munchie people. All right. The other two, the litigation is still ongoing. And in one of those, there was a separate criminal enforcement proceeding brought in the Eastern District of New York. So I'm just sort of looking at this. I'm just saying, well, look, I don't see a rational.
Well, it's also anyway. I don't want to comment on ongoing cases.
Perfectly fair. Perfectly fair.
Well, it's also anyway. I don't want to comment on ongoing cases.
Perfectly fair. Perfectly fair. But it's really hard for me as a counselor to be able to tell someone Here are the distinguishing characteristics that explain when the SEC goes after an ICO, and here are the situations that explain when the U.S. Attorney in the Eastern District of New York is going to go after an ICO. Although the Zaslavsky situation was just a flat-out fraud, he didn't even have anything on the blockchain, right? He just said the magic word, blockchain, 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 right? And he thought he was going to get off, but that was just plain vanilla traditional fraud.
I hope this episode has brought you some value. Like and subscribe. And be ready because this SEC case against Ripple is going to affect the whole crypto space. This is the Digital World Podcast, and I'll see you in the next episode.